Hi, I'm attorney Nicholas Ricada of Ricada Law, a small law firm in central Minnesota, and in today's video, we are reacting to Locked Up for a Protected Act from the Lackluster channel. Let's get right into it.
Welcome back to the Lackluster channel. Today's story was passed to me by Wrights Crispy, who informed me that a Democrat candidate for Florida Congressional District 3 was attending the Big Family Extravaganza. The carnival was set for Sunday, January 30th, 2022, hosted by the Hispanic, Black, Asian American, Women's, and Pride student unions.
That's a whole lot of student unions.
As well as the Inter-Residence Hall Association.
Ooh,
the event
IRA.
was open to the public and held on public property at the University of Florida's Flavet Field.
Okay, we're going to get into why that's important in a little bit, that it's open to the public and held on public property. That's going to be a recurring theme. Lackluster is very good at setting the stage
Tom
here.
registered for the event and set out to talk politics and discuss an upcoming election. And even though his political platform is aligned with the event organizers, and the fact that the University of Florida is a well-established public forum that supposedly honors and defends free speech, the organizers became upset with his presence and asked Officers Smith and Espinoza to remove him from the premises.
So what we need to do is, before we can continue, what we're supposed to do, if you ask him to leave and then we can go from there.
I already did.
You already did?
I already did.
And he refused to?
He refused. He said he had like freedom of speech and.
Okay.
What a dummy. Who would think that in a public place you might have freedom of speech? In America in 2022? Somebody get this man an aspirin.
Because it's like a public university campus. But
I mean, like, why?
How it works,
Why would you like have free speech there?
Permission to hand out anything for reverence through the campus.
Okay, yeah.
No.
So at that part, we're good with where?
First of all, no. Second of all, no. You doesn't need to have permission to hand out something in person-to-person interactions. That's just insane. But let's keep going.
With the beanie.
After locating Tom, the officers
what's up, Tom?
approach him as he is having a conversation with an event attendee.
How you doing? Jesus, come over for a second. Yes, sir.
So he's talking to someone, two police walk up, be like, hey, can you come here for a second? Extremely embarrassing. You never want this to happen. I mean, I'm not talking about anything legally actionable at this point, but this is just like, this is the thing that police know that they can do. And it's one of the soft tyrannies that really drives me nuts about police interactions. I mean, same thing with just pulling someone over. Everybody's looking at you now. Everybody's looking, oh, this guy's getting talked to by the cops who walked up on him. The guy he's talking to, you know, it damages your credibility and reputation just straight out the gate. And police know that they can flex that on people.
I believe contact was made with you earlier from the event coordinator here. She didn't want you here. My concern is that you're here, you're handing out cards. Is it something about voting for you or something on that point? Okay.
Yeah, of course.
At this point, have you been through the rights union to get that approved to come through here with that?
You know, I have been here campaigning for 6 years at every public event. Every public event.
That's good.
And I've never had to get permission.
No, understand what I'm saying.
People are having conversations.
Are you gonna let me talk?
I'm sorry.
Okay.
No. One, first of all, he maybe shouldn't talk to police. Don't do that. Don't talk to them. They're not your friends. But two, are you going to let me talk? No, piss off. I don't need to let you talk. What are you talking about? He's explaining what he's doing there. He's explaining his reasoning. Are you going to let me talk? It's needlessly hostile already.
I guess at this time, the coordinator got their attention. You got their attention from some kind of way because somebody said that you were kind of harassing them. And that could be true, could be not true.
Okay, it's really important if that's true or not true. And a spoiler alert, that never comes up again for the rest of this video or any of the paperwork or anything. And I think that's one, either the police officers just lying, which police officers are allowed to lie. They're not allowed to base their actions on the lie if they know they're lying, but they are allowed to lie to try and obtain compliance or to obtain any sort of information out of someone. They can lie about things like that, which bothers me, but it's true. But this, if it is true, if he was actually accused credibly, or even not really credibly, of harassing someone, the police would have justification to remove him from the event, and the harassment could be sorted out at a later time. But this vanishes, and it really bothers me that this does not come up again.
But at this point, this is a bit for students.
Nope.
Okay? This is an event for students.
Well, every event at UF is pretty much for students.
Correct. And so at this time, the event coordinator do not want you here. And for me to observe you handing out that paperwork without permission from the campus, we can ask you to leave. So the correct way to do it.
So he says that since the event coordinators don't want him there, and because he's observed him handing out the paperwork without permission, he can ask him to leave. It's kind of sketchy. Since this is a public event, which we'll get to in a minute, it makes it a little bit difficult to determine whether or not the police officer can ask him to leave. But typically, if you're at an event and there is an organizer and the organizer says, I'm going to have to ask you to leave, then you no longer have permission to be there. You have to have some outside source permission. The question is, does the event coordinator have the authority to make that request in the first place? And you can kind of argue that they do. They do. It doesn't have anything to do with the passing out of, materials necessarily. Other issues here is the student unions are private entities. They may be under some sort of state control or authority. The police are obviously state actors, but the questions of does he have free speech here really hinges on whether the state is infringing on his speech, therefore has the university granted authority to these student unions that mirrors the university, and it kind of seems like they may have, because he can get trespassed off of all university property as a result of this. Or do they not? Is that authority genuine? These are the questions that'll need to be asked later.
Officer Smith alleges that the event is for students and that Tom Wells is not allowed to engage in political conversations or to hand out his business card. However, the event is still posted to Facebook and shows that the event is open to the public.
Oh, it says public, but it's behind my picture.
The University of Florida
Sorry.
campus is public property, and based on their policies on political campaigning on campus, they are committed to the principles of free expression, including the exchange of political viewpoints and ideas for all members of its community.
But again, the question is this event a University of Florida event, or is it a student union collaborative event? So that would be, that's hosted on the university property. Is the university a publicly funded institution? Is that using its authority on this guy? Or are the student unions acting as private entities who happen to be in a public space that they have the right to be in, and they have the right to control the occupancy of? And if they do that, if they are private, and this is a fact question, there's a lot that we would have to do to analyze this, but if they are just in fact a private entity in temporary possession of public land who have gotten permission to be there and then be in control of the space, then even though it's public land and even though the university may have these policies, the actions of the private actor come into play. And again, this is a fact-intensive question, and you can make arguments on both sides of it. But if it's the University of Florida acting as an agent of the state, you have one answer. If it's a private entity acting as a private entity on temporarily granted permission of public property, you have a completely different answer.
In their regulations, manned distribution is expressly permitted without the need to ask permission. The only requirement is that the literature being passed out must be handed out by a person, not left unattended, such as a sign, banner, or sticker. Thus, Tom has been acting well within the laws and even the policies of the university, and neither the student organizers or university police department have the authority to quell his right to free speech or ask him to leave because of it.
Again, and I hate to beat on this, but there is a difference between being on public property and state-funded land and being at a private event on public property where the private organizers have temporary control over that area. That is something that can be done. Usually it's done through the permitting process. You'll see this when a protest has received the proper permitting to protest in a certain area, like at a public park. If someone else comes in and disrupts the protest, they have the right to ask that person to leave because the permit grants them the right to be there and gives them temporary sort of private authority over that as if it were a piece of private property, because effectively for the moment it is. And that's a big question here again on whether or not he's actually able to do this. If this is in that private event, the regulations of the University of Florida don't actually grant him the authority that he would want because, well, he's not on University of Florida time. He's on this private group of student unions time and then their rules. But then there's that complicating question. Are these student unions and associations acting as the University of Florida? And again, very complicated fact pattern here that would be argued by both sides in a courtroom.
I'm not going back and forth with you, so we can go ahead and leave.
Yeah.
All right, thank
We
you.
can escort you out of the premises at this point if you can just walk to the exit. We actually need to see you legal.
Under what authority is a good question, but there may also be a good answer. Again, going back to the previous analysis, if it is a private event, then they have requested police to escort someone away from their private event. I know it says public, but if they have private control, that means they still get to control who's there. Because like you can't have just like, oh, it's a public event and then have someone doing something that is completely disruptive to the event, even though it may be otherwise lawful. You say, well, public land, you can't do it. If they've got exclusive use and control of the land and someone's there and you don't want them there, you say, hey, take off or I call the cops. You don't have the right to be here. I get to exercise the authority here. It's called the right of alienability, and it's one of the critical property rights that denote ownership, whether that ownership be temporary or permanent. The right to alienate others from the property is a measure of whether or not you have control or access to the property at that time.
And the event is, by you giving out those cars, you making it political, and this is not a political event.
Obviously a political event.
The attention of the person who's in charge.
Like, look at the unions involved. It's clearly a political event, just not in the way that they mean it, but okay.
I've never needed authorization. I've done this.
I'm explaining that to you. You just made out knowing the rules. That's all it was.
The question is, what rules is he under? Is he under the rules of the University of Florida, or is he under the rules of the private event? Very different things.
Well, I'm explaining them to you.
Things have changed. You do need a authorization to do that. And like I was explaining,
Things have not changed. It's just a question of which authority you're under. Officers are really bad at explaining law. They're police officers. They're not lawyers. They're the practical enforcers. They make things happen, and they use legal authority to do so. But they're often really kind of terrible at explaining the reasoning behind it.
and she said, please escort him out of the premises. So at this point, we need you to go.
The irony is that the officers tell Mr. Wells that he didn't know the rules and that things have changed. That political speech on property that we pay for now requires authorization from unelected school officials. The truth is, nothing has changed.
Again, and look, Lackluster's heart is in the right place, and I agree with him on a lot of the principle here. And even in the context of this, I agree with what he's saying. But let's flop the scenario a little bit. You go to a public park and you get a permit to host a birthday party for your 8-year-old, right? At a public park. And you say, okay, well, there's like a shelter there that's owned by the city that you pay like $20 to rent it out. You know, you got like some grills and stuff, and you've got this little area that's yours. It's like, oh, this is the Nick Rekieta Shelter for Justice of whatever city you're in, right? You're having a birthday party for your 8-year-old. Everybody's having a good time. And then some dope comes up and he starts handing out his political cards to like the guests, and he's talking to little kids. He's like, hey, can I interest you in being a Democrat? To like a little kid. And then he goes up to like the moms and he's like, you know what? You need to raise your children right and have gender reassignment. Whatever they say, right? Like they start campaigning at your child's birthday party. Now, there's no prohibition on campaigning on public property for the city. None of that. However, you've now got a permitted event that's happening in a specific place that these people, the event holders, the birthday party throwers, have a right to. And now we've got a different story, right? Like, we can't expect that every birthday party that happens just because it's at a public park, someone gets to come up and start handing out political campaigns. They could be like, hey man, can you knock it off? Can you go somewhere else? And if they don't leave, what's your option? Well, you're at a public park, just too bad. No. When you're under that sort of private authority, you've gone through the channels to obtain permission to have exclusive control of a public space for a limited period of time under the rules and regulations set out by the public authority, you've now converted that public land temporarily into a private place. And so while I kind of agree with what Lackluster is saying here, and I also think this situation is needlessly ridiculous, lots of things that are needlessly ridiculous might still actually be legally valid. And in here, I think the narrator of the video is asking some of the wrong questions. Now, if I was on the side of the guy being bothered by police here, I'm asking the same questions. I'm making the case from that perspective. I'm saying the things that Lackluster is saying. I'm just presenting that there is an alternative argument from the state that is not unreasonable and is certainly within the bounds of law, but it is a fact question on if that authority exists or if that authority is just derived from the university. Those things change everything in this question.
But these officers are not only wrong about the principles of free speech, they are also uneducated on the legal requirements.
So they've got the legal elements. Willfully entered upon property other than a structure or or conveyance. The property was owned by or in the lawful possession of person alleged. That second part might be that group of, well, the event organizers. Property was legally posted. We know this is University of Florida property. We know that the event is happening here. The event is advertised on Facebook. The location is there. The tables are obvious, all of that. The property was either a construction site, commercial horticulture, property, an agricultural site for testing or research, a domestic violence center, an agricultural chemical manufacturing facility. I'm not sure what this number 4 is. And then entered the property without authorization, license, or invitation from, or any other person authorized to give that permission. But see, trespass doesn't just stop at the time of entry. Trespass also continues up until the point where you're asked to leave. So you can have permission. That permission can be revoked. And when that permission is revoked, you have to go. See, what they did here is it looks like they grabbed jury instructions from some case that is a little bit more specific, or maybe they're the criminal jury instructions, the basic format of them, and they would need to be modified for whatever particular case you're running. But these are informative, but you have different questions. For example, number 4 obviously doesn't apply to this event in any way. It's completely separate from this thing. Nothing under number 4 applies here. So, but yes, a trespass at the time of entry into the property is one thing, but you can also be trespassing when your right to be there has left. But again, looking at number 2, and this is what Lackluster seems to overlook, is the property was in the lawful possession of, in this case, the student union organizers. That would be a critical question to a criminal trespass here.
Also uneducated on the legal requirements to effect a criminal trespass, and due to their grave misunderstandings of the most simple concepts their job requires of them, they now attempt to arrest Mr. Wells.
One other thing here is that Lackluster is overlooking is that a criminal trespass is one thing, a civil trespass is a different thing, and police can effect the removal of someone for either a criminal or civil trespass. Just criminally, like police aren't just involved in criminal trespass. If they are called to assist in the removal for a civil trespass, they can do that under their lawful authority, which is going to be a really important point coming up. And Lackluster, I think, is going to miss it as well. Again, his heart's in the right place. I actually agree with him on all of the concepts in this video as applied to this situation. But my job is to talk like an attorney, not talk like an impassioned rights activist.
Let's go this way, sir. We can talk and walk. Come on.
Without warning, the officers now arrest Mr. Wells, during which they twist the 70-year-old man's arms behind his back, causing...
He had a little bit of warning. They didn't say we're going to arrest you, but like things had been leading up. He's refusing to leave. They're trying to affect this removal, and he's not doing it. But yeah, they don't expressly say, I'm going to arrest you now.
Causing Officer Smith to injure his knee. This seems to upset the officer, allegedly causing him to force Mr. Wells' wrist to the upper portions of his back. Officer Smith writes in his supplemental report that Mr. Wells tensed up, fell to the ground, and that his arm was placed behind his back. No mention of the excessive force was documented.
Excessive force is a legal conclusion. That means that the force used by the officer was greater than what was reasonably necessary to affect the lawful actions of the officer. It's not necessarily happening here. It's nice inflammatory language. It works out really well. But look, I don't like the fact that officers will often say someone is resisting arrest when what they're doing is they're taking their arm and they're twisting it behind their back. Of course your muscles tense up. Your arm doesn't move that way. It's an unnatural movement. The older you get, the less natural that movement tends to be, unless you're in a particularly specific fitness and flexibility. A 70-year-old man having his arm twisted behind his back, he's going to have tighter shoulders generally than someone who's maybe 26 and working out all the time, right? So once that happens, yes, the arm is going to tense up. I don't think that that's a resist of arrest necessarily, but that is often used as justification for resisting arrest. This will, of course, become a fact question, whether that is part of the resisting. Falling to the ground intentionally can be a resisting of arrest. The resisting arrest statute is actually really, really important here because it's a little bit broader than what it seems.
Officer Espinoza failed to report that they had taken Mr. Wells to the ground. The handcuffs were put on in such a way that they caused lacerations to Mr. Wells.
Handcuffs are made of metal. They're not smooth. They've got some hard edges. They often cause lacerations. It depends on what it is, but laceration, abrasion, any sort of tearing or breaking of the skin is often mentioned. It often sounds really bad, and a lot of times it's just what we would see as a scrape. Now, I don't like this, again, but we don't know how bad the cuts actually are. We just have this very bare recitation of facts from the incident report. They could be really bad and deep lacerations, or they could have been just basic skin wounds from the fact that you have metal clamped around your wrist and it moves around. That'll rub your skin raw and cut you open.
He was then transported to jail and charged with resisting without violence under Florida Statute 843.02, which leaves us to question what Mr. Wells was arrested for.
Wrong question. And this is, again, a place where Lackluster is going to take the first part of the statute, resisting. The other part is obstructing. Now, the Florida statute actually says that it is any lawful act that is obstructed by someone is part of this resisting or obstructing statute. In this case, if the officers are lawfully asking him to be removed for a criminal or civil trespass, if the authority is given to the event owners or organizers to have private control of this space temporarily, and they ask him to leave the space, he refuses to. They can contact officers who come and ask him to leave the space. He doesn't leave the space. He refuses to comply with a lawful order to move. Then he is obstructing without violence. He is within this statute. He is technically guilty at that point. It has nothing to do with the handcuffs, the tensing up, the resisting by falling, anything like that. Any obstruction of any lawful act can be resisting or obstructing without violence. It's critical to note that while this is being framed as resisting arrest, there is no requirement that any arrest occur or that any probable cause for an arrest occurs. Only requirement is the officer in the lawful commission of his duty at the time that he's doing something, and is the alleged offender resisting or obstructing that lawful inaction of duty. So in this case, if the officers have the authority to remove him for trespass and he refuses to move, is under the statute. Whether he's going to be arrested or not is irrelevant.
Resisting arrest is a secondary charge to an offense that required an arrest in the first place.
Not true. That's an incorrect statement. Sorry.
He wasn't arrested for criminal trespass. Instead, he was given a notification of trespass warning.
Now, if this notification of trespass warning is within the authority of the police officers to effect, because it's a civil trespass that is removing his access to the University of Florida properties, and they have the authority to do so because the event organizer has it. Now, interestingly, because this covers all University of Florida properties, he gets to make the further argument that this is done by the University of Florida, not by the event organizers. And again, we get back into that back and forth fact question that we can't answer in this video, but you can make good arguments on either side. The event organizers have authority to remove people. They're able to do it, but the University of Florida is the one affecting the removal at, in this case, I think 3 years, the next 3 years. Like, that is kind of going beyond the thing, but there is a way to strike a happy medium. The judge could determine that this civil trespass is invalid if he follows the process highlighted down below if you think this is an error, but the trespass removal at the time can still be valid. Those are different questions. Again, lots of stuff going on here between criminal and civil. And that your criminal arguments don't necessarily mean that you win your civil case either, or lose. Either way, they have different standards, different burdens of proof, different rules of evidence, and different considerations.
Barring him from the public property for 3 years. Note that he can appeal the trespass, but only through the University of Florida police chief. So the case should be dismissed, right? Well,
no, actually, no. And I would love for it to be true that it was right. But I think right now, probable cause exists to say that this guy was, in fact, obstructing lawful execution of duty by police officers. It pains me to say that. I am very much not pro-cop in general, but here, the police are acting under apparent authority from the organizers to remove a guy who's disrupting a privately held event. Even though it's an open to the public event, they're in private control of this space for the time. They have the authority to remove someone. Police officers doing that. He refuses to comply. He's obstructing. That's under the statute. Now, all sorts of defenses, all sorts of questions. If it's the university, then do they have the authority to remove from someone for speech? Way different. But those are for court. Therefore, probable cause to say this? Sure. I don't think this case should be dismissed.
Not so fast. Mr. Wells' trial is now set for Tuesday, June 28th of 2022.
That's because of what I just said.
Witnesses in previous hearings say that even the prosecutor appears to think the case is trash, but admitting it will make this already easy civil lawsuit a grand slam.
I don't think this is an easy civil lawsuit, by the way. There's lots of reasons for it, and they're not all great, but you have qualified immunity for the police officers themselves. They're acting in a way that they're kind of supposed to do as ordinary course of their job. You also have them very possibly acting in a way that they have every authority to do so. Or the other thing is that they've made a reasonable, honest mistake that is harmless to the guy. Like they say, well, you know what? Like we thought we had the authority to do this. This is, again, for the civil lawsuit that he's saying is a slam dunk. If they have apparent authority to do what they're doing, and if they're acting in good faith, which they do seem to be, as much as I'm not a big fan of cops, they seem to be acting in good faith here and saying, no, you know what? These organizers want you gone. We got to move you. You don't have a slam dunk civil lawsuit here. Not at all. But what you do have is a very complicated set of questions. You may have a defense to the criminal trespass. That doesn't mean you're going to win against the cops. In fact, most people don't, even when they win their criminal cases.
This is incredibly embarrassing for the department, officers, and the university, despite the many disagreements we may have with Mr. Wells' political affiliations and views. This treatment of an elderly man for speech is unacceptable and should be viewed as a vicious assault and battery by his own employees. This
My heart says yes, I want to agree with you. The law says otherwise.
Is a prime example of the definition of tyranny. When Rice Crispy attempted to obtain the body cam footage in February, they stonewalled him, claiming they couldn't release the publicly owned footage because the case was too big.
All this part is very nice and dramatic, but this is completely irrelevant to any of the legal questions that we have in this case. The one thing you should know is Florida is called the Sunshine State, not just because it's so super sunny, but also because they have fantastic sunshine laws, which are, you know, government transparency. And this footage was ultimately released. I mean, they met with a little bit of resistance, but it was released to someone who has no particular interest in it, which is how it should be. But they're going to make a lot out of this, and this isn't relevant at all to the case, in my opinion.
So this case was actually requested before by somebody else, and it was going through our general counsel to be released. Let me see with them to see if they've released anything to that requester.
Yeah, it's very common, by the way, that a public entity, while they may be under a duty to release a document, a video, or whatever, their general counsel, the attorney for the public entity, is going to make the determination on whether or not that needs to be released now, or if they have some other use for it, or if there's some compelling reason for them to not release it at present. Just because they eventually have to release something doesn't mean they have to release it to this person at this moment. And again, this video was ultimately released, so we know that it was eventually fine.
If you have them available, there shouldn't be any obstacles presented or any red tape on this. This is one of the most liberal public records law in the country.
Yes.
So let's
yeah, but they're still going to run it by the city attorney. Like, they're going to do that. What if they have to obscure someone in the background? What if they have to hide an identity to protect someone? Like, that's the things that they're going to look for before they're just going to release it. Look, this is a really interesting case, obviously, because we have tons of considerations that are not mentioned by the narrator of the video. But that's why attorneys exist. We have to make everything complicated. It can't be straightforward and simple. And personally, on my personal opinions, I'm on the side of lackluster here. I'm on the side of the alleged defendant. I think that, you know, the rules as stated by lackluster are what they should be. But we don't live in a world of should. We live in a world of questions. And in this one, we have so many questions that I brought up through the video. Hopefully, you guys are now asking those questions and looking at things in that particular way. But what do you guys think? Let me know down in the comments what you thought of the video, of the incident, of the police officer's actions, of the alleged defendant's actions, of all of that stuff. Drop comments down below. Make sure you click a like on this video if you liked it. It really helps out. Make sure you subscribe, of course, to this channel. You can check me out too if you want. Don't tell anyone. Check out these other two videos that are gonna pop up on your screen, because there's a whole lot more attorney reactions on a whole lot of different scenarios. And some of them are by me and others are by slightly less handsome people. All right, thanks guys for watching. I hope you enjoyed this video. Have a good one. Peace.
Big verdict.